The petitioner and the first respondent and the first interested party have on their part strongly urged the court to dismiss the application for want of jurisdiction. This sentiment was supported by the Law Society of Kenya as a second amicus curiae. Counsel for the first interested party submitted in that regard that this court needed to be consistent in the manner it determines applications before it. In his view, the application before us was similar to the one brought to this court recently by the first interested party, in which he sought an interpretation of the meaning of the words fresh election in Article 140, Subarticle 3 of the Constitution. The application was struck out on the ground that the proper forum for the determination of that issue was the High Court. Counsel therefore urged us to treat the present application similarly and remit the same to the High Court. We have considered all submissions as to whether this court has jurisdiction to entertain the application or not. From our sentiments expressed in the foregoing paragraphs, it must be clearly discernible that we entertain serious doubts as to whether this court has jurisdiction to clarify its judgments. Having pronounced ourselves authoritatively on the issues that were placed before us in petition number 1 of 2017, it was this court's expectation that all parties thereto would act in accordance with what they understood the court to have meant. This application does not also fall within the purview of Section 21(4) of the Supreme Court Act. This court has no jurisdiction to interpret its decisions or those of other courts. On the face of it, therefore, in ordinary circumstances, an application which is based on tenuous jurisdictional foundations, such as the one before us, ought therefore to be dismissed. However, we are keenly aware that the questions whose clarification the applicant seeks arise from the recently decided presidential election petition, a determination that continues to elicit considerable public interest. It is also our view that this application is not similar to the one by the first interested party that was recently dismissed by this court. In that application, the applicant had sought an interpretation of a constitutional provision as a matter that was not an issue in petition number 1 of 2017. Had this court entertained the application, it would have usurped the jurisdiction of the High Court, contrary to its established traditions and tenets. We have, in the above context, critically considered the submissions made by Messrs. Muite and Kiragu, urging us not to turn the applicant away, given the enduring public interest in the judgment that has triggered the application. To that limited extent of great public interest, we think that the submissions by the two counsel are not without merit.